Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm your co-host, Thomas Vick. Seth Wilson, the other co-host, joins me. Seth, how are you today on this January afternoon?
Thomas, I'm doing great. It is definitely wintertime in Indiana, where this morning the weather could not decide if it wanted to snow or rain or figure out what it wanted to do. So we're definitely getting into the throes of winter here. But I love living in a place where there are multiple seasons, and hopefully we'll get a little bit of wintertime. I can handle snow for a little while, but then it gets pretty tiring after after a bit. So
My philosophy is if it's going to be cold, you might as well have some snow, at least some snow at some point. So hopefully we'll get a little bit of something, but we are going to have some nasty weather here this weekend, I think.
yeah, the forecast looking at the negative numbers, I was not looking forward to that. But bundle up, stay warm, But when you're inside, it's a good time to be thinking about some of those projects that need to get done. And one of them is always on the list is getting your estate plan set up. And I was reading through the blog digest this morning that you sent out and talking about how do you do this estate planning for children, and that the post, I guess, did a good job of really kind of taking you from young children all the way up to where maybe you're the child helping plan for your parents a little bit. So I thought it'd be a good thing to talk through today.
Yeah, so kind of the first part of the article is the foundation of estate planning for parents, and really, I come from a perspective of having a trust as the foundation of the estate plan. You can have a will, and it does some things pretty well for you, but a trust can be a really solid foundation for taking care of children if something were to happen to both parents. And so, there are different kinds of trust, but sort of the starting point is having a revocable trust in place. And that can be the vehicle where all the individual's assets can be funded into it. And that can be of great assistance to the children.
Yeah, and there's so many great benefits to having a trust in place, because I think one of the concerns we're always trying to address in our planning is the during life disabilities, whether that be a short-term disability or a matter of convenience, where you need to act on your spouse's behalf, for example, or a longer term situation after one of the spouses has passed. And so that trust is very flexible, works hand in hand with powers of attorney to cover that during life situation that you may face. And you don't have to work through a guardianship process and those kind of things. And I think that's one thing that I talk to with my young family a lot, is that the importance, and I think we mentioned this maybe a week or so ago, the importance of naming the guardian for minor children and the trustee associated with that. And that's often the same person, but really making that designation in your documents can give you that peace of mind for the during life portion, which hopefully most of us have still quite a bit to live.
It's so important to have that clarity on who that guardian and who that trustee should be, so that when something unfortunate happens, you're able to go to court and say, "Hey, so and so wanted wanted us to be the guardian of these kids," and it's very clear from the last will and testament what the judge should do, at least in understanding the intent of the those that have passed away. And there are different kinds of trusts. You can have trusts that are established during the parent's lifetime, and you can have trusts that are established after death. And there are pros and cons of both. You can have a revocable trust during life, and you can have a testamentary trust after death. The testamentary trust would require that the will be probated, so that there's a public record of what the will says and who is to be the trustee of the testamentary trust. But the testamentary trust is a little bit disadvantaged in my mind because you actually have to file something with the court prior to it really
Yeah.
being established. And tell clients, and I kind of get this from you, kind of do the work ahead of time so that you're not to have somebody else do the work for you after your passing. And so it kind of depends on how much effort you want to put forth during your lifetime, and especially in the estate planning process. But those are some considerations.
Yeah, and that's a great point because the ultimate outcome could be this relatively similar. The thing I think about as the balance is how much do you want to know to a reasonable degree of legal certainty that the plan is going to be in place with as little room for variation as possible.
Yes.
And if you have a trust, a revocable trust that has all the terms set out the way you want them as a family, that's probably the most certain you can be that that plan is going to be in place with as limited amount of variation, right? So if you have a will-based plan with that testamentary trust, there are some gaps in terms of what might happen. A judge may read those terms and say, boy, I don't know if that's we're able to do that, right? We've introduced another decision maker into the process. Maybe there's a dispute that arises afterwards, and so there's some discussion about that, and the judge is forced then to make a call as to what really are the terms here. And so, to get the most comfort that you can have, I think that revocable trust really helps set the stage for you as you go through your life. Again, limiting the amount of variation that could happen.
And you think about some financial provisions that might be included in your estate plan when you're thinking about minor children. You could have 529 plans for the children built into your revocable trust, and you could have life insurance proceeds to funnel into a trust to take care of the kids when you're not there to support them financially any longer. Those are a couple great ways of providing for kids in the future, and really, really a great way to bless them when you're not otherwise able to be there.
Yeah, and I think that brings up an important point because anytime we're doing estate planning, it's a great time to review your beneficiary designations. And when it comes to minor children, especially, you may have special types of accounts that are kind of already set up for the benefit of the minor child with a custodian or someone watching over the division or the distribution of those proceeds. But in your life insurance context or your retirement plan context where something unfortunately happens to that couple prior to them intending to and the children are still minors, those beneficiary designations become really important. And how do you get those assets into a protected scenario rather than going to the children outright, so to speak?
Yeah, absolutely, absolutely. And there are some unique circumstances that parents have. One of them might be that one of their children might have special needs, and so government benefits might be exceptionally important for that family and maintaining those. And a lot of government programs do not allow for you to have more than $2,000 of assets to your name. So parents need to kind of plan around that. And one of the best things that you can do is to establish a special needs trust for that child. And it can be funded at least somewhat during life, but then can receive the bulk of the inheritance, if you will, upon the parent's passing. And that would allow for the child's government benefits, means tested benefits to continue, uh, while also being able to supplement those benefits with things like, money for vacations or money for uh, maybe medical devices that are not covered under Medicaid. Items like that can be really, really important for parents to consider.
Yeah, and it's interesting too, as you go through life, there are scenarios that come into being where someone does become disabled as a result of an accident or some issue that arises during life that wasn't anticipated. And so having some provisions in your documents for that event is also critical. But making adjustments when those scenarios do come up to make sure that any fund, there's not sort of the law of unintended consequences that apply, where you may have wanted this outcome but never got the documents updated to really reflect that and protect the provision of those benefits that are means tested. So it's a good thing to do. And as your kids kind of age into their life, right? So they become adults and things, there's other things to think about. I thought your blog post did a really nice job of setting some of those out. The big ones I think about in that context is sort of that in between period of time when the child becomes 18 and is legally considered an adult, and the time that they may graduate from trade school or college or whatever their next phase of life is, until they may get married and start their own family or start being a little bit more independent. Those powers of attorney from the child back to the parent can be very helpful in those contexts in the right scenario.
Yeah, absolutely. So you can be in a situation where the doctor or the school can't provide any information to the parent because the child who's been brought up for 18 years is now 18 years old, and there are privacy rights that child now has. And it's really, really important to talk about those things with your kids as they're turning 18 and going off to college or trade school or what have you. So that's definitely a good point. And then kind of the last one is, once you've done that, make sure that you're reviewing your estate plan. Maybe every 5 years is a good rule of thumb to take a look at your estate plan and see if you need to make any changes, but really it's life event sensitive. So when there's a life event that happens, death in the family, change in an address, marriage, divorce, new child, all of that kind of stuff, those are events that you should really take the opportunity to open up your will, open up your trust, and see if it meets your intended wishes at that point in time.
Yeah, and I found, and this is anecdotal. I don't have a study to back this up necessarily, but I have found that many folks who have experienced a probate process come to me and say, I don't want that experience for my children.
Yes.
I want to make this a little bit easier to navigate. How can I do that? And that goes back to what we were talking about in terms of the trust initially. But that, again, I don't have statistics to say that would be, in 90% of the cases or 50% of the cases. But it is a general sense of, I want to do the best I can to prepare as well as I can for what's next and make that transition as seamless as I can. And so that's a big part of why I enjoy what we're doing as a legal practice area, because we get to be a little bit more proactive with the law and be prospective rather than reactive, which is, unfortunately what we find ourselves in if we're in a litigation scenario trying to figure out what happened. And so that's a good thing. If planning ahead and that's sort of your personality, that would be really beneficial for you to do everything you can on this side of things to get your affairs where you want them to go, and take note of the experience that you may experience when you go through one of those life events.
Yeah, and Seth, you and I are in a unique position where we see a lot of these cases, and we see sort of how things have ended up on matters that we've worked on, and so we can kind of say, this has been my experience. This is what should have been done to avoid this result, this bad result. And so it's really important to go and talk to an experienced estate planning attorney, because while you can get a lot of wills and trusts online, you don't have the experience of an estate planning attorney to say, well, yes, if you make that choice, it could work out, but there are some significant risks to that choice of plan, and here's what I would do. you don't have that kind of experience if you just use somebody online. And so definitely talk to an experienced estate planning attorney, whether it's you or me or somebody else. It would be really, really helpful for individuals to talk to somebody that has experience.
Yeah, and really that's the key, right? We're trying to provide some educational material as to what you should think about in these contexts and really put that information out so you can make informed decisions. Who actually drafts that plan is a personal choice between you and the lawyer that you're comfortable with and maybe located next to, right? So that those are all good things, but it's really an important thing for us to make sure that those plans that we feel led to put together are what is going to be accomplished and not leave that up to chance, because there are, like you say, Thomas, there's so many different avenues now, and well, it'll work out, or somebody else will figure it out. They probably will, but it may not be as seamless as it could have been. And if that's what your plan is, great, then you figure that out, right? But most of us kind of want to have everything detailed a little bit more than that, make things as easy as we can on those um, of our loved ones that are coming behind us, and kind of modeling what that looks like for their next generation.
Absolutely. Absolutely. Well, Seth, how can people get in touch with you?
Well, if you are in Hamilton County and need services up in our neck of the woods, we are right in the heart of Hamilton County in downtown Noblesville, and that's our web address, noblesvilleattorney.com. How about you, Thomas?
And the best way to get in touch with me is by going to the website, vicklaw.org. You can click some links there and be able to schedule time with me. So vicklaw.org is the best place. Well, Seth, appreciate it as always, and we'll see you next time.
Sounds good, Thomas. Stay warm.